It hasn't gotten better yet.
Okay.
Joe, since we only have two, can we do a conference call the other way? Just call them in and merge them in, see if that works.
I don't know what you're suggesting.
Call, conference
Usually
call.
those, yeah.
Can try it. Well, there's three of them.
There's two. Shane's not on.
Oh, okay.
Shane had a meeting.
Hey, well,
Steve, what number are you on?
write them down. As soon as you hang up, they hang up and go away.
There, you can use some official.
Either that or I can send them Google links.
7. 6:30. When I was commissioning anyway.
Steve,
Yeah.
Tim, I'm going to ask you guys to hang up, and I'm going to call you directly as opposed to using the Uber and see if it makes any difference.
It's not bad. As long as the passes are still.
Steve, I can see you talking, but I don't hear nothing from you. So go ahead and hang up.
Some candidates I the pass, and then show back landing. My brother's trucking cattle 2 days. I'm hoping it stays that way. Because our go to Speedway base, so that's where sort of towards the
Can you disconnect them?
If the roads are good.
You come over last night.
I'm like 3 hours away.
Voted this morning.
I voted like a month ago.
Oh.
The party you have dialed is on the phone. Hi, you've reached.
I was
Busy too.
for something else. And we had to go out to the courthouse to do something. Oh, my brother had to go get his voter ID cards with his driver's license.
Oh.
Okay.
Because we don't get mail on our names
Just
to our
you can, if you
physical
want to.
address.
You can.
Oh,
Because we so anyway, so we had to go to the voter registration. So what you do is you go to the courthouse.
The person you are trying to reach is not
You gotta have your car registration and your voter ID and your address. So we were in there. And I said, well, go ahead and vote.
Yeah.
So I voted like a month ago.
Now,
so you vote in Rollins?
No, I
hung up on
voted bats, but you can go in the courthouse.
Oh, the county courthouse. That's, yeah, we could have done that. We could have.
Sounds like you guys have some drama on the sheriff deal.
Well,
It made the news. Everybody's like, but we don't actually know what happened. It's just what his mom said.
oh, that was
That kid.
that was
Tim?
that was in town. I don't think that was the police.
No, it's just.
Was it? Okay.
Tim,
Yeah,
are you
I
there?
read the article. We were,
Yeah, I'm still here. I just can't hardly hear you.
we were
Gonna have to live with it
driving around
as best you can.
and wife and I was getting caught on the street with all these cops. I said, what's going on? And then we found out yesterday it was yeah, that was
I'm sorry.
the
Your
it
call
sounds
cannot.
like the person that killed was mentally, so who knows what happened. Feel bad, but if they on their meds or something, they can really.
This is Steve.
Steve, this is Jim. Can you hear me now?
Unfortunately, it's still very quiet.
So this thing must be.
Tim, are you there?
Yeah.
I put you on a conference call. I know it's not any better, but it's the best I can do today.
Okay. So do you need to call me back?
Nope, just stay on there.
I'll talk loud into this thing. Okay, we ready?
You got any other?
Good morning. It's November 6th at 9:12 a.m. I'm Megan Lally, the chair of the Environmental Quality Council, helm of the State Library, 2800 Central Avenue, Cheyenne, Wyoming. Present today from the council are Dr. Dave Bagley, Deb Bomber, John Cora, and myself in person, and Tim Flitner and Steve Lentz on the phone. Staff present today are Jim Ruby, Joe Girardin, and Ryan Shellhouse from the Attorney General's office. Do I have a motion to approve the minutes from the September 25th and October 22nd meetings?
I'll move that we approve the minutes from those two meetings.
Second.
It's been moved and seconded. I can't remember. Roll call? Yeah.
We can just do a voice vote.
Yeah. All those in favor?
Aye.
Aye.
Opposed? Motion passes. The first order of business is to approve the order of dismissal in docket 18-4801 Knife River 2017 Burnett Pitt application. Knife River withdrew its permit application, resulting in the case being no longer necessary. Do I have a motion to approve the order of dismissal?
So moved.
Is there a second?
I'll second.
It's been moved and seconded. All those in favor?
I think this is.
Aye.
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 Opposed? Does this need to be roll call? Or is that one? Okay. The next item on our agenda to the public hearing for docket 18-3103, a rulemaking package from the Water Quality Division of the Department of Environmental Quality, amending Chapter 27 of their rules. Would the members of the division please have a seat, introduce yourselves, and go ahead and make your presentation.
Morning, Madam Chair, members of the council. My name is Kevin Frederick, Water Quality Division Administrator. And today I have with me Miss Lily Barkow. And Lily is the groundwater section manager within the Water Quality Division. She's responsible for implementing the underground injection control program at EQC. The underground injection control program is a federal primacy program under the Safe Drinking Water Act. So we essentially operate under federal rules and regulations for the most part. Today, we're here to present to the council some background on a rulemaking effort that we have before you with respect to requirements for financial assurance on coal bed methane produced water injection wells. Financial assurance requirements are intended to be able to provide surety for the state in the event of operator default of these injection wells, that there are sufficient resources available for the state of Wyoming to essentially administer plug and abandonment and site reclamation responsibilities. As you know, over the years in the coal bed methane development, primarily in the Powder River Basin, so operators have gone under default and essentially left the state of Wyoming with the responsibility to plug and abandon some of these coal bed methane produced water injection wells. Fortunately, we've been able to work with the Oil and Gas Conservation Commission to begin to get some of these orphaned Class 5 coal bed methane produced water wells plugged over the years, and we expect to be able to do so. With that, we'll turn this over to Lily, and Lily will kind of walk you through a little bit of the background and history on this rule development. Thank you.
Good morning. So the Underground Injection Control Program, or the UIC, has 6 classes of wells, and the Water Quality Division has regulatory authority on Class 1 deep disposal wells and Class 5 UIC wells, which are any other facility not included in Class 1 through 6 that dispose of fluids into the subsurface. Since 2014, the Department of Environmental Quality, Water Quality Division has worked to address the burden of closure, post-closure, plugging and abandonment, and reclamation of CBM impoundments and wells that were orphaned due to declining revenues. For these Class 5 coal bed methane produced water or nutrient wells, 980 wells have been authorized by permits, and 491 of those wells have been constructed. 318 wells are covered under the Wyoming Oil and Gas Conservation Commission plug and abandon program. 173 wells are not covered by either the Oil and Gas Commission or DEQ. 75 are currently operating, but without OGCQ financial assurance, and have an estimated cost to close and reclaim of $1.125 million. 98 are identified currently as orphans with no viable operator identified and have an estimated cost to close and reclaim of $1.47 million. In order to prevent the state from bearing the burden of future reclamation and decommissioning costs in the case of operator default, the Wyoming legislature enacted Enrolled Act Number 2 in 2018. This act directs the division to revise Chapter 27 to include financial responsibility requirements of all UIC Class 5 coal bed methane produced water injection facilities. It also clarifies the existing financial responsibility requirements of UIC Class 1 hazardous and non-hazardous well facilities. The financial assurance requirements proposed by the division and authorized by SEA 002 exceed the federal requirements of 40 CFR Part 144. Department met with the Joint Minerals Committee on June 30th, 2017 in Casper and briefed the committee and offered recommended statutory language for DEQ to proceed with a rule to require financial assurance on existing and future Class UIC 5C5 injection wells. The department briefed PAW on this issue on August 15th, 2017. The Wyoming legislature enacted Enrolled Act Number 2, or SEA 002, in 2018, which establishes the applicability to permits issued, renewed, or transferred after July 1st of 2018, directs DEQ to initiate rulemaking before July 1st, 2018, and makes this act effective July 1st, 2018. The division met with the Water Waste Advisory Board on June 21st, 2018, and presented the proposed modifications to Chapter 27, Section 19. The division received approval to present the modifications to the EQC at that meeting. In conjunction with this meeting and requirements of the Administrative Procedures Act to adopt rules, DEQ commenced with a public comment period from September 5th through October 22nd, 2018. The DEQ received one written set of comments from the U.S. Environmental Protection Agency. DEQ has posted an analysis of those comments to the EQC docket, and DEQ has proposed additional edits, which were also uploaded to the EQC docket. Modifications are identified in the green font copy of the edits that the DEQ are requesting today to the proposed rules from September 2018, which you should have a copy of. The written set of comments provided by the U.S. Environmental Protection Agency included 4 comments. The first identified in the CFR that authority is available to require financial assurance to all Class 5 permits. The department does not propose any modifications pertaining to this comment, as the specific Class 5 CBM wells are identified for financial assurance and not all Class 5 wells. The next comment notated where the CFR and DEQ deferred in regards to financial mechanisms approved for use. Federally insured automatically renewable certificates of deposits, U.S. Treasury bonds, bills or notes, and cash are not identified in the CFR. The department has determined that these are the appropriate mechanisms for financial assurance and are ultimately more stringent than the CFR identified as instruments of self-tests or corporate guarantees, and therefore does not propose any additional modifications for the identified section of Chapter 27, Section 19. The third comment noted that a cost estimate must equal the cost of plugging in abandonment at the point in the facility's operating life where it would be the most expensive, specifically for Class 1 hazardous waste injection wells. The department has proposed the modification to include that a cost estimate must equal the cost at the point in the facility's operating life when the extent and manner of its operation would be the most expensive. And the final comment identified that the CFR required that financial assurance for Class 1 underground injection facilities provide a demonstration of financial assurance within 30 days rather than the 60 days as proposed in Chapter 27, Section 19. The department has determined that this modification is needed and is requesting that edit. On behalf of the Director of the DEQ and the Water Quality Division, we request that the Council approve the proposed rules as amended on October 31st, 2018, and the Statement of Principal Reasons on 2018. Thank you.
Thank you, Lily. Madam Chair, members of the council, stand for questions.
Madam Chair, this would be either Kevin or Lily. The Oil and Gas Commission had some role to play in some of these wells with regards to abandonment and plugging. And are there going to be any conflicts with them going forward? Are they clear about your responsibility for these wells? So do you see any conflict with the Oil and Gas Commission for owners of abandoned wells, if you will, or that's even a misnomer, but operators, let's say, of existing wells, trying to push back on a DEQ regulation because they believe they're paying that tax into the Oil and Gas Commission's fund for plugging and abandoning? Have you worked that out with them, or?
Madam Chair, Mr. Cora, we had numerous injection wells that went into default that
Excuse me, Jim and Joe, is there any way you can turn that volume up? It's still pretty challenging to hear what's being said.
Hey, Tim, this is John Cora. Can you hear me?
Just barely, John. I mean, I got to have my ear right to the phone, and I'm missing about every third or fourth word.
This doesn't work. Okay. Well, he's gonna take my mouth shut.
Then we won't be able to hear you for sure.
Blind blood this.
I'll just stop asking questions.
Should speak.
I can hear you well enough to suspect you're making jokes at my expense, John.
No.
No, he's making jokes at his own expense.
I don't know. I couldn't hear the joke, but I could hear everybody laugh.
Well, here was the joke. You were complaining about not hearing me, so.
Perfect.
Okay. What Ruby did is pull out some duct tape, and I was thinking he was just going to cut me off by taping my mouth shut. That was the joke. Can you hear it? Can you hear me better?
Yeah, that's great. Whatever you changed, that's great.
Okay. Madam Chair, I'll just repeat the question now. And the question stems with the coordination between the DEQ and the Oil and Gas Commission regarding the plugging, abandoning, and reclaiming of these coal-bed methane wells. And Kevin was just getting started on the answer when you asked for a break. So.
thank you, Jim.
Bless.
Madam Chair, Mr. Cora, as I was saying, many of these coal-bed methane produced water injection wells, when they were essentially abandoned, were what we call co-injection, co-producers. So they were alternating between essentially producing CBM gas and then injecting additives, nutrients, et cetera, to try and stimulate more methane gas development. So in these particular cases, the Oil and Gas Commission did hold a reclamation bond on them because they were actually producing at the time. So when they went into default, the Oil and Gas Commission essentially had bonding funds available for the reclamation and have taken on the responsibility of reclaiming and plugging and abandoning those wells. For the subset for which neither DEQ or the Oil and Gas Commission holds bonds, as I said, the Oil and Gas Commission has been working with us to try and get those wells plugged and abandoned as they work through their plug and abandonment program that they've been working on for several years now. So they're picking some of these up. We haven't heard that there's been any problem or any issues with respect to operators either challenging the Oil and Gas Commission's ability to use those funds to plug these injection wells. I guess I'm not anticipating that, but in the event that does happen, I suspect the director of DEQ and supervisor of the Oil and Gas Commission would get together and figure out a path forward.
Okay, thank you, Madam Chair.
Are there any other questions? Tim, Steve, do you have any questions?
No. No, I do not.
Okay, well, seeing no more questions, I'm present to testify in support of the rule package. Is anyone present to testify in opposition to the rule package? Anyone present to testify in a neutral capacity? Do I have a motion to approve the rule packages and the statement of principal reasons?
So moved.
Is there a second?
I'll second.
It's been moved and seconded. I'll take a voice vote. Deb?
Aye.
John?
Aye.
Dave?
Aye.
Tim?
Aye.
Steve?
Aye.
And I'll vote aye also. The motion passes. Thank you very much.
Madam Chair, thank you very much. We'll present you with a copy of the statement of principal reasons for signature.
Great, thank you.
Give me 1 second.
Problem with new technology is it's
Actually, it's old technology.
Make sure you hit speaker again before you hang up.
They changed our phones to digital.
Polycom still analog, so it's fun.
Oh, is that the problem?
I think it's the Polycom. When they switched us over, we stopped using them because they wouldn't work properly in the conference room. But you know, if your batteries on your new good digital equipment die, then you don't really have much of a choice.
Okay.
Why do they analog device and digital connection?
I just figured it was different equipment that always takes some breaking in.
Okay.
Okay, thank you. The next, can you still hear me? Tim?
Yeah,
Okay.
I can too.
Okay, great. The next item on our agenda is a public hearing for docket 18-1101, a rulemaking package from the DEQ affecting Chapter 1 of the Rules of Practice and Procedure of the DEQ. Members of the department, please have a seat, introduce yourselves, and go ahead and make your presentation.
Good morning, Madam Chairman. I'm Joe Franken with the DEQ Management Services Division. With me today is DEQ's Public Information Officer, Keith Gill. and Allison Queen, Agency Counsel from the Attorney General's Office. Thank you for giving us the opportunity to discuss the incorporation by reference of A&I's uniform rule. The rule, titled Uniform Procedures, Fees, Costs, and Charges for Inspecting, Copying, and Producing Public Records, allows for a standardized approach for all state agencies to charge a fee for the production and construction of electronic public records, and also establishes a copy and transmittal fee. The Wyoming legislature supports this action through its mandate in Wyoming statute. The uniform rule was codified in Senate Enrolled Act 47 back in 2014. Governor Meade supports this action, which creates uniform rules on procedures and fees related to the production and construction of electronic public records. DEQ has presented the uniform rule to the Water and Wastewater Advisory Board, the Land Quality Advisory Board, and the Air Quality Advisory Board. All three boards have recommended adoption of the rule to the council. As you're probably aware, we met with the Air Advisory Board several times before they were comfortable and ultimately recommended adoption. A&I conducted the public notice and public comment process concerning the uniform rule. Therefore, it's important to note that the rule has been vetted through a public review and public comment period. As you are aware, incorporation by reference allows agencies to incorporate the rule in its entirety, given the required public review and comment processes have been completed. It's also important to note that when A&I went out for public comment, which was 16 February of 2016 through 8 April of 2016, they received very few, if any, public comments. So they actually extended the public comment period through 9 May of 2016 and ultimately held a public hearing on 12 May of 2016. A&I proposed the uniform rule to comply with the legislative mandate outlined in Wyoming Statute 16.2.204E, which directed that A&I shall adopt uniform rules for the use of state agencies, establishing procedures, fees, costs, and charges for the inspection, copies, and production of public records under Wyoming Statute 16.4.202DI, 16.4.203HI, and 16.4.204. The rule complies with that mandate and creates uniform rules for use by state agencies. Additionally, Wyoming Statute 16.3.103JII requires that each state agency ultimately adopt these uniform rules. A little background on the rule. The uniform rules establish production and construction costs related to electronic public records, again authorized under Statute 16.4.202DI. The uniform rule also establishes production and construction costs at $15.50 per hour for clerical staff time, $30 per hour for IT staff time, and $40 per hour for professional staff time. And another important aspect of the rule, it creates a minimum dollar threshold that must be met prior to any production or construction costs being charged for electronic public records requests. So for example, if production and construction costs for electronic public records are less than or equal to $180, the applicant or requester will not be charged any production or construction costs. And I've asked Keith to kind of walk through some examples that DEQ has where this kind of falls within the uniform rule and how that would apply to DEQ.
Thank you, Joe. Madam Chair, the majority of our records requests that we get are more of a phase one environmental assessment. So it's a lot of times where someone's doing their due diligence on the property. And that's what it's in. Where these would come into play would be a lot towards email correspondence. The majority of those can get quite voluminous. We've had one where it was, they asked for 5 coal-fired power plants and they wanted some records which we've been working to produce, those physical records, but electronic correspondence for one division, for one facility was 49,000 emails. What we were able to do was work with them to try to, to bring that number down a little bit. We were able to bring that down to 7,000. So put this in perspective, what that would take for us to do was 7,000 emails times 2 minutes, let's say, per email. That's 14,000 minutes. If you were to break that out in a month or for one person, it would take one FTE 29 days to fulfill that records request for 7,000. So that's really where that time is coming for us. We have to look at, the attachments, be able to see if there is any trademark, confidential. It may have to do with even personnel. It may have nothing to do with the actual request, but because of a term, maybe before that facility came out, we may have to pull that record out because it doesn't fulfill the request itself. Other requests that we've gotten as well, this one would not apply to the actual threshold because they're physical records, but this one was for 85 facilities, and they were looking for all permits and applications and other documents. And to date, our staff has spent 20 hours doing this. Now, we still would not charge for those. And so our staff is still going to, with this rule package in place, we'll be still doing that type of work when someone wants those physical records. And there would be no cost to the public.
And I think, Madam Chairman, just to put on the record, DEQ takes public records requests seriously. And as Keith alluded to, in recent years, these requests have been increasing and consuming significant staff resources. Just to give you an example, in 2015, DEQ had 509 records requests. In 2016, we had 516 records requests. In 2017, we had 614 records requests. Thus far in 2018, the first 10 months, we've had 637 public records requests. And I think it's important to note that those public records requests fall essentially into like 3 distinct buckets, and so the first bucket, and Keith can probably elaborate on this a little bit, is probably 90 to 95% of our records requests. And those are consultants doing phase 1 and phase 2 assessments. And those would fall underneath that $180 threshold. In other words, there would be no charge for those. And that's about 9% of our public records requests. The second is what we call industrial due diligence, which is facility and permit transfers. And those would be a very small percentage as well. The last are special interest groups. And we looked at it, approximately about 3% of our public records requests would fall within those special interest groups. And that's the example that Keith gave of those 45 to 49,000 emails. And working with the requester, and this is an important part of the rule, which we'll talk about in a second, by having the rule, we can go back to the requester and say, that request is 45,000 emails, but working with the agency, we can narrow that scope and make it a little bit more specific. And in this case, we narrowed it from the 49,000 down to 7,000 emails. So anyway, I think that's important to kind of get an idea of how many records requests DEQ receives annually. And that, again, the vast majority of those are going to fall below the $180 threshold. In other words, there would be no charge. I think it's important too, and I just wanted to walk through a few of the comments some of the comments that A&I received during their public vetting, public comment period, and then some of the comments that DEQ received here over the past year as we've gone to the advisory boards and ultimately the EQC. So during the public hearing, A&I addressed several comments that opposed the rules and had concern about A&I's legal authority to create these uniform rules. A&I explained that during the 2014 legislative session, the legislature created Wyoming Statute 164204E, which required A&I to adopt uniform rules for electronic public records and non-electronic public records. And on the non-electronic public records, in Section 5 of the rule establishes fees for copying and fees for copying non-electronic public records. Wyoming Statute 164202DI specifically addresses electronic records inspection and copying. It requires that the reasonable cost of producing a copy of the electronic public record shall be borne by the party making the request. The cost may include the cost of producing a copy of the public record, and cost of constructing the record. DEQ believes these rules make electronic public records requests and the subsequent production or construction of those more efficient by encouraging specific and detailed requests, which help both the requester and the state agency. Commenters expressed concern that the cost for the production of electronic public records could lead to less transparency in government. And A&I stated during their public comment period that the fees are not designed to create less transparency in government, but rather to follow the mandate, the legislative mandate, to encourage more specific and detailed requests for electronic public records and to alleviate the burden on state agencies. So some of the comments that DEQ had received, one suggested DEQ should comply with the Environmental Quality Act's core mandate of open records to make all agency information available, and that charging fees to access records creates an unlawful barrier by charging an access fee. And DEQ, working with the AG, has confirmed the incorporation by reference of the uniform rule is not in conflict with the Wyoming Environmental Quality Act. There is no fee for inspecting DEQ's public records in person, and I think that's critically important. Anybody, we would like for people to have an appointment, but it's not necessary, but can come in and review a record, a paper record. We can get the record, a permit or whatever, and get it out, and they can review that. There's absolutely no fee for that. This fee directly impacts electronic public records, the construction and production of electronic public records. Another comment suggested DEQ should not charge a fee to the public related to records that are part of the agency's permitting enforcement or rulemaking process. And again, there's no fee for the inspection of public records. This uniform rule, again, allows for a reasonable fee for the production and construction of electronic public records. Another commenter suggested DEQ needs to develop internal procedures that produce records faster and make more information available to the public, as opposed to limiting access to public records. And again, I'm going to ask Keith, I think this is critically important as well, of some of the things DEQ has done recently to make public records available online. So,
yeah, certainly. One of the things that we felt was really important first is be able to manage these records requests and make sure that they're being responded to. When you're getting 700 or 600 a year, you can probably imagine it doesn't feel good if one slips through the cracks. And so with what we've implemented, it's called Next Request. And we have everyone log in or do the request online. And immediately it comes to me, and then I assign these to divisions or staff. It keeps track of where this record request is and making sure that it's being fulfilled. And so, today we've been able to respond to records requests within 8.5 days. And I think that that's pretty significant for us to be able to do that. Additionally, we agree that we'd rather have all of our documents electronic. And so we're working towards that process. Our Ben and Mineland program now has all of their records online through the state archives. So I think that was an important step moving forward. Additionally, yesterday we made available, it's called Open Air, and it has all of our air quality facility records back to 2014 now available online. So staff and the public can actually get online. I do suggest that you all do check it out. You can actually look up all type of facilities. So if you're interested in, let's say, Laramie County, you can just put in Laramie County and look at all the facilities that we have permitted, and then all the associated documents. As we move forward, our staff will be adding more and more documents that go back even into archives. And I think that that's important because in our air quality division, they have 135 filing cabinets in-house. We're going to be moving again, and so I think all of us would rather not move those filing cabinets. So for us, we'd like to get those into the system. Additionally, we have 1,700 boxes in archives in air quality. I think that would be our next step to start working through that process. But it takes time. We've got to go through each file and make sure that it's not confidential or trademark type of information. And finally, we have this, it's called the Site Profiler. It's like a map type of Google aspect that someone could put in an address And then from there, they could actually do their environmental assessment type of record search. I believe if we can make that available and make that fully active where they can look at enforcement actions, the last time we actually did inspections, that type of information will definitely reduce the amount of requests that we have. And I think that that will make a lot more public friendly with our agency and be more transparent.
Thank you, Madam Chairman. And so kind of walking again through, I think this is the last comment that was kind of the general theme of comments, was adopting the uniform rule will violate the terms of DEQ's primacy agreements with EPA and OSM, Office of Surface Mining. DEQ has reviewed this rule, and the uniform rule will not violate the terms of primacy. I think it's important to note that 44 states have similar laws in place for their environmental agencies. So, and the other states, our understanding is, are working towards that. So, as far as the concern with primacy, we feel like that there is no conflict with primacy. So, in wrapping this up, in no way is DEQ attempting to limit access to public records. The fees are not designed to create less transparency in government, but rather follow the legislative mandate and encourage more detailed and specific requests for electronic public records. Voluminous public records requests stretch agency resources, and this legislatively mandated uniform rule will lessen the burden on state agencies and assist the applicant in narrowing the request. Again, important to note that thus far, approximately 35 Wyoming state agencies, commissions, or boards have adopted or are in the process of adopting the rule. And within DEQ itself, the rule has been adopted by 2 divisions, AML and industrial siting. So today, DEQ is requesting the council's approval to incorporate by reference the rule into DEQ's Rules of Practice Procedure, Chapter 1, General Rules. We propose adding a new Section 11 titled Public Records Requests. And with that, Madam Chairman, we'd be happy to address any questions anybody may have.
Deb?
I don't have any questions.
No.
John? I have a couple. You've answered some of my questions, so I'm trying to get through them. So the 3% is the special interest groups asking for information. How much time does that small percentage of requests take as opposed to the other 97%?
Yeah, if I could answer that, Madam Chair. For us, I'll use an example. I'm working on one myself, going through emails. And what I'm looking for is anything that may be confidential, attorney-client information. And I flag those. And then ultimately what I'll do is I'll hand that over to the AG's office and have them confirm that I'm right or not. And that is just taking me probably about 3-4 hours right now. And obviously that's not the only duties that I have for the agency, but certainly I'm focusing on it. So again, I think it's best if I try to put a number to each email, and I'm thinking, well, let's say 2 minutes. So you can just kind of do the number there, what that may take. And that's my time. That's not the time of ETS having to pull those emails, as well as the AG's office having to do their review, and obviously doing their confirmation on what I've been flagged.
Okay, thank you. Sorry, Jim. So you're charging fees for copies if they come into the office and want a copy, correct?
Currently, we are not, Madam Chair.
To charge for copies.
And that would start at the very beginning. So if someone wants one copy, it would be, I think it's 10 cents. Is that correct, Joe?
That is correct.
10 cents per copy.
Under the new rule, but under our current policy, we have a de minimis 25 copies are free. So, and unfortunately, the uniform rule that A and I put together, there's no de minimis in that. So if somebody comes in and wants one copy based on the uniform rule, it's going to cost 10 cents. And that's going to, for us, one of our challenges will be, and I've met with our fiscal staff, is we need to come up with a like a cash management policy on if that happens, how we're going to manage that.
So there can't be, I'm just trying to figure this out. There can't be an exception to the rule to say 25 copies are free. I mean,
And Madam Chair, no, because since this is a incorporation by reference, that we're taking the rule as written.
okay.
I think I can add on to that point. So the statute that the legislature passed says that each state agency, quote, shall adopt as much of the uniform rules promulgated pursuant to the following provisions as is consistent with the specific and distinct requirements of the agency. So unless we had some kind of requirement to provide 25 copies free, we would not be able to write in another provision into A&I's rule.
Okay. And if they brought in, I know they make like hand scanners, if they brought that in, that wouldn't be an issue?
No, they're currently doing that now.
Okay. And then counties right now get their documents, have gotten their documents scanned, at least our county has. And then all of a sudden now, if you want to access the documents online, you have to pay a fee to the company that's holding the documents. I assume that's who it is. And it's like $5 a day or $50 a year or something. We're not going to go towards anything like that, right?
No.
The state's going to continue, anything that they put online is going to be, at this point, as far as you know.
Yeah, you're correct, Madam Chair. We'll continue to, anything that we have electronic, and if we have applications, like I mentioned, those will be free of charge, is to have electronically where, they'll be able to access things.
Okay, so your goal long-term is to get all the permits and all of the applications and all of that online and free in the future?
Yes.
Okay. I think that's all I've got. Dave?
Yeah, I've got, I guess, a couple questions and a comment. I guess the first comment is I remember, boy, it's been over 25 years ago when I was working on my graduate degrees. I'd be in the library with a whole roll of dimes, feeding them into the copier. It was free access, but to get a physical copy, I had to put the money into the copier. So I don't know, 10 cents seems, if you want a hard copy, you got to pay. Someone's got to pay for the paper, right? And that's kind of. I guess my question though is just other ways to think about this. So there's obviously a lot of cost to DEQ for some of these. And so it'd be, one way to do it is if you just hired a staff person who specifically just did that. And I imagine the legislature has not given you a position to do that. Is that correct?
Madam Chair, Dr. Bagley, we have staff that are assigned to doing records requests. Obviously, they have the other duties as well. Our land quality actually has a records management. I think they have 2 staff, but again, they have other duties. Our water quality division also handles records requests, and they're working on getting those scanned and working through that process. Our air quality division has 1 staff member that handles the records requests in the sense of doing the review and then working with the public to provide those. But in a sense, if it's just one specific person and that's all they do, I'm not sure that we have that. But the legislature has been very good to us and the governor in the sense of providing the funding that we need, whether those are applications or whether that's the staff that we have currently.
Okay, thank you. So if everything then, let's say looking forward and you've got all of the current, I guess they're currently non-electronic records and you're scanning them in and putting them online, so they would be accessible through the internet for free to somebody who would like to look at those. But right now they're currently free if they're non-electronic records, unless they want an actual copy. Is that correct?
That is correct, yes.
Well, at this point, if it's more than 25 copies, because you're giving them 25 for free, but yeah,
yes,
okay.
Yeah.
So they come in and say, I want a copy of this, whether you have to go dig through those archives or not. If it's a non-electronic record, they're getting that for free. And that would still be the case with the new rule, except for the 10 cents per copy.
Yes, Madam Chair, Dr. Bagley, that's a great point. And when I first talked, we had that one records request for 85 facilities, and most of those documents, if not all, but most of them are in archives. So our staff has had to go through the records, and some of them, it may be difficult to find, but they're going through them, and there is no charge for doing that, and there will be no charge in the future because those are physical records.
So the staff time required to dig through the archives and the mask to protect from the mold and everything. Right?
Exactly.
Okay. So that still will be. It's just so what we're really talking about with the new changes. If someone wants specifically an electronic record, I'm trying to. What's an electronic record versus the non-electronic? What types of records are they? Obviously, I know the ones that are on systems and others aren't, but what types of records are they that are electronic versus those that you've got in archives?
I would say the majority would be email correspondence, and we don't house the emails in our offices. We have to go through the ETS. ETS will pull those records, and then that's when we have to develop those, construct those, and then in a sense do our review, and that's where that charge for time would be. Up to $180 threshold, we would not be charging. But once it passes at $180, that's when we would start charging per hour. It just depends on like a clerical is $15.50 an hour. IT is $30 an hour, and then professional, mainly like the AGs, would be $40.
So can I hire a lawyer elsewhere for $40 an hour? I mean, it seems reasonable to me, but I'm just trying to get a feel for what. So if we have everything scanned and put online, we'll still have all these emails that are out there that people may be requesting to see, and that would still require processing and apply to this fee would apply to that.
That's correct.
And folks pay the fee up front and get it back if they're under that. Is that correct?
Yeah. So what we would do is we would do maybe a search first with ETS, and let's say they want everything with my name on it, right? Mm-hmm. And so we would say, well, you've got 5 emails. It's probably more than that, but let's say they have these amount of emails. We would then say we would put our time of what we'd come up with a analysis, let's say 2 minutes per email, and say this is what it's going to cost, and this is what you're going to have to owe us after we reach that $180 threshold.
Okay.
And they would pay us up front.
So they'll pay for the whole amount up front, 180 minimum, but a whole amount. Will you estimate?
Track the $180 threshold first.
Okay. All right, that answered my questions. Thank you.
Tim?
No, don't have anything.
Steve, do you have any questions?
I do not. Thank you.
Okay. Is there anyone here present to testify in support of the rule package? Anyone present to testify in opposition to the rule package? Please stand up and state your name and who you're with. And
hello. Today I'm speaking on behalf of Powder River Basin Resource Council as well as our members. At first, I want to emphasize that these records are very important to the public. They contain information about industrial facilities, air quality, impacts to water resources, and other aspects that affect the livelihoods of our Wyomingites. Our organization usually serves as a conduit between the public and the agency. We don't just request records for the sake of it. We request these records so we can participate in the permitting process and DEQ's decision-making process. We strongly feel that electronic records should be made to the public just as paper records are. That is required by the Wyoming's Environmental Quality Act, and we know from experience that paper records are very limited, and electronic records are usually just the way things are these days. We don't have a lot of people writing letters back and forth. Those emails have been really important to us in getting information to participate in the comment period. Sometimes our requests exceed the $180 threshold. We guess that most of them have, but we've obtained really significant information in those emails that we would not be able to get in DEQ's paper files. Our organization is based out of Sheridan, Wyoming. Luckily, I'm located down in the southern part of the state, so if this rule passes, I will be able to come by and inspect public records in person, but it is really difficult for us to receive those electronic records from afar if we are going to be charged for them. In response to our comments, DEQ has claimed that federal environmental laws have similar language about records accessibility and charge fees. That is true, but those federal agencies also have fee waiver provisions where organizations like ours are never charged for requesting these records. We've never been charged under the Freedom of Information Act by either the EPA or the Office of Surface Mining for electronic records. Also, DEQ claims that they're under a legislative mandate to adopt these rules. We believe that's simply not the case. DEQ points out that the legislature directed them to adopt as much of these uniform rules as is consistent with specific and distinct requirements of the agency and state or federal law governing or applicable to the agency. No other agency has its own record laws like DEQ does under the Wyoming Environmental Quality Act of Section 1101. DEQ has specific and distinct requirements that prevent the agency from creating significant barriers to these records to the public. Again, in this day and age, these electronic records are extremely important to the public, and charging high fees for these records would create a barrier to our accessibility of them. And with that being said, I can stand for any questions.
Dave?
Yeah, how is your access being limited if this is approved?
Madam Chair and Dr. Bagley, our access would be limited by having to be charged high fees for these emails or correspondence that allows us to participate in the DEQ decision-making process.
So it's a financial barrier is what you're not being limited. You're still able to access it, but you just have to have the funding in place to be able to get it.
Madam Chair and Dr. Bagley, that is correct. And I hope you can understand that organizations like ours are primarily funded by our members as well as grants, and it would be difficult to come up with those high amounts of money for fees if we would need them, and it would create a barrier to our organization.
And so we've heard that the DEQ is going to move to put a lot of records online, accessible to folks. Does that address your needs?
Dr. Bagley, Madam Chair, sorry, Dr. Bagley, that in a way it would, as Mr. Gill just said, a lot of the information we are requesting is in emails that allows us to participate in the process.
So the emails are not going to be online searchable, is what I've heard. So those you would still have to request if you wanted email traffic.
Madam Chair, Dr. Bagley, that is correct, as I understand.
So I guess this is just perhaps a rhetorical question, but someone I guess needs to ask it. So who pays for this, these activities? I mean, the information is accessible. It's publicly available, so it's not hidden behind somewhere. It's not private, but there is an actual cost to either a staff person's time that they may have been used a different way, or if we had to hire just a one, sole person is like, your job is just to answer all these and do all this, which could be a solution, but the DEQ has lots of other things right now. They got people doing multiple jobs trying to do it. But I mean, real money is being expended on this. Who should pay for it?
Madam Chair and Dr. Bagley, I can understand your concern about this question, and I do feel that my organization does our best to not request insane amounts of records to create a burden on agencies. However, I feel that under the Wyoming environment, it is the responsibility of the agency to provide these records to members of the public.
So your feeling is that the state should pay for it because of the law and this, but I'm just, the state has to get its money from somewhere. And I know I pay income tax to the federal government, so I hope I could go get something from them for free, but I don't pay any income tax to the state government. So I'm just, I guess rhetorical question about someone pays for this in the end, because it's real, there's real effort going into this. And I'm just trying to get a feel for how that might happen. And I don't expect you to have the answer, because the proposal is that people who are requesting should pay for some of it, and frankly below cost at $40 an hour for legal fees. So I'm done rambling, Madam Chair.
Yes.
Another question.
Let her, I think she had an answer, and then you'll have the next question.
Madam Chair and Dr. Bagley, I agree. It is real money being used in real ways, and it would be up to the agency in this case. But I just hope that moving forward, the Department of Information and Administration can consider a fee waiver provision for organizations like ours that are simply just trying to access these records.
Okay, thank you.
Yeah, Madam Chair, I just want to come back to your comment about our act and what actually section 1101 says. And I don't read it the way you are reading it at all. And in fact, there's a section in here that allows you to recover any costs you incur if you prevail in a legal proceeding. So can you say more about how, your position on 1101? Because all this has to do with is charging a fee to give you the record. So I don't see your argument here, and I'm just like, if you can clarify that, that'd be good.
Madam Chair, Mr. Cora, I'm not an attorney. I'm a community organizer that works with impacted folks around the state. But as I understand from our attorney, Section 1101 of the Wyoming Environmental Quality Act has these distinct requirements that would prevent the agency from creating these significant barriers to the availability of public records. And we strongly feel that charging high fees for these public records would create a barrier to it.
Okay, well, Madam Chair, I'm that's fine. My comment is we'd let attorneys argue that if they wanted to, but I don't see the validity of that argument in my read of the language. Okay, thank you.
I have a question. As I was reading through all the comments, there was one from Jill Morrison, who's with your organization, and she says, "No reason open door policy and welcome the public to review documents and copy documents at no or minimal cost. In recent years, DEQ's policies for public access to records that impacted adjacent lands, water, and air are much more difficult to access, and DEQ has become much less transparent and more restrictive." Can you address that? Because according to the DEQ, they haven't changed their policies, and according to this, it's gotten harder to access the documents, and I want to be clear on what's going on.
Madam Chair, those were not my words exactly, so I don't want to speak on behalf of our executive director, but I assume that she is talking about timeframes it may take to get access to public records, or perhaps she is speaking to this future rulemaking, which would create this barrier for us.
Can I ask the DQ a question real quick? So have you changed your policies on letting people in to look at documents in the past couple of years?
Madam Chair, we haven't changed our policy in the sense of someone being able to come in and look at our records. What we have done, we developed the guidance because we felt like we needed to have something very clear for the staff to understand what the rules were and what the regulations were in the sense of like trademark and confidentiality. And so that's one thing that we've had to do, is to ensure that those records that are going over don't have that type of information in the physical form. I think we've made huge progress, not just here in the Cheyenne office, but also in our field offices. Our field offices still have the records as well available. The primary record resides here in Cheyenne, but our policy has always been the same, that we try to work with the public as much as possible to have that access to those physical records.
Add something to that. So back in 2015, DEQ formed the Public Records Task Force, which put this policy together that Mr. Gill talks about. And essentially we had representatives from each of the divisions and the Attorney General's office. And we put together a policy and then supplemented that policy with the policy guidance, or with a guidance document. And I think that it's very comprehensive. One of our challenges has been, and it's probably something that we could do better at DEQ, is to communicate that out, especially to our field offices, to make sure that our field offices understand the policy and are following the policy. And in my time, I've been at DEQ about 2 years now. One of my goals has been is that, hey, we have this really good policy in place. We need to make sure that we're following the policy. And some of the things is that, we request an appointment. We just, it works better for us time-wise and efficiency-wise if we can get an appointment instead of somebody just showing up saying, hey, I want to look at X number of documents, which we accommodate that, we actually do. But I think from the efficiency standpoint, if we could, and those are the types of things in the policy that it talks about, to be able to make appointments, to have a way to maintain chain of custody of the documents, to ensure that if somebody comes in and they're reviewing documents, that we want to make sure that the documents are put back together in an orderly fashion and things like that. So.
Okay, thank you. Yes.
And if I just might add a comment to that, Madam Chair. We have really appreciated the DEQ's initiative to create a website to have public records online. So we congratulate you for your work on that, and we hope that you will look forward to a fee provision waiver for public interest groups like ours in requesting these specific emails.
Okay, thank you. Deb? No questions?
No questions.
Tim?
No. Madam Chair, I actually do have a question for Monica. My question is, have you or your agency reviewed your previous year's record requests from DEQ to provide an example of what these new fees, if adopted, would cost your agency?
Can I repeat that for you?
Yes.
He's wondering if you've gone back to look at what you've requested in the past and how much it might cost you to have made those same requests in the future under this fee restriction.
Madam Chair, am I speaking to
Mr. Lentz?
Mr. Lentz. Mr. Lentz, I'm a more recent staff member, but I would be happy to provide you with an example that our attorney has given me. For instance, in the case of Ramaco, we learned that there were tens of thousands of pages of agency emails and associated attachments related to that permit. Most of that information was not available to the public in the paper files at the DEQ office. We know because we looked at that paper file regularly leading up to the filing of our objection to the permit. Since that hearing, we've regularly been requesting emails and attachments related to Ramaco. I think the agency might be able to tell us whether it has exceeded that $180 threshold, but our guess is that most of them have. Once again, we've obtained very significant information in those emails that is not available in DEQ's paper files. Did I answer your question?
You did, thank you.
Madam Chair, I ask a question. So for that particular case, Ramaco, I recall the Powder River Basin Resource Council submitted a request for some funding back from the DEQ, and they weren't the only one. I think some of the other people involved with that did too. Did you get some funding back for fees that were associated with your participation in that hearing?
Madam Chair and Dr. Bagley, I don't have that information to answer for you. I'd be happy to follow up and directly answer your question.
Does anybody from the DEQ have that answer?
Madam Chair.
Dr. Parfit?
Yeah. This is Todd Parfit, Director of the Department of Environmental Quality. The answer to that question is that there were agreements with the Powder River Basin Resource Council on their request, consistent with the statutory provisions that allow them to ask for those compensation of funds. And so Powder River Basin and there was another entity as well. But I believe those funds have not been released pending the outcome of the litigation that's in district court.
Okay. Thank you, Director Parfit.
So, Madam Chair, so the statute's working. 1101 is working just the way it was intended.
Are there any other questions for Powder River Basin Resource Council? Thank you very much.
Thank you.
Is there anyone else that would like to testify in opposition to the rule package? Is there present to testify in a neutral capacity? Do I have a motion to approve the rule package and statement of principal reasons?
So,
is there a second?
Second.
It's been moved and seconded.
Perhaps, Madam Chair, let folks, if they have any comments to make before we vote.
Okay. Would the DEQ have any further comments? Or council members?
Yeah.
Sorry.
Right.
Well, we want to make sure we have. This is a very controversial thing. I want to make sure we understand every piece of it. Deb?
no, does anybody think we need to have our attorney weigh in on anything, or are we okay?
No, I think the Attorney General's office is already, according to the testimony of the DEQ, already stated that they think these rules are okay.
All right.
Madam Chair, I just in discussing, for purposes of the discussion, there is, I think, a couple of points I find significant. One is anybody can go to the agency in person and get a copy of a record or inspect a record. Down the road, it's going to get better with all this electronic filing. To me, it feels like the central issue for the opponents has to do with accessing emails, which, in the agency, there are lots of emails that go back and forth there between any agency and the council, for example. And that's where a lot of the time, and Keith even gave us a specific example of that being one of the big hitters. So my sense is that for opponents to the rule, the the central issue is really getting at these emails so that you can understand what went on behind the scenes, which I don't have a comment on that at all. I just say, well, that's what they do. But generally speaking, that does lead up to some kind of litigation. As it turns out, in the Ramaco case, which was the one specific example that was raised in our hearing today, there is an attempt made to compensate them for those fees, just as the act requires. So I don't see that the act itself prevents this rule from being put into, and I think it gives some clarity to everybody as to how the process will go going forward. And I think it's moved the agency to set up some processes so that you can manage it better. I do worry a little bit about some employee being kept accountable for a dime in petty cash. And I would hope that none of your employees get caught up in some, because they misplaced a dime somewhere. I thought that, I'm surprised at that number, but be that as it may, that's strictly just a comment there. But I think, Madam Chair, this rule package is fine as it is. And I think redress, if there is one, needs to take place in another venue. And that venue really is the state legislature. That's all. Thank you.
Dave?
Yeah, I've been following this as it's working its way towards us, as the air quality advisory board having, concerns about this and having to meet a couple times on this issue. And so I've been thinking about it, and of course see it in the newspaper and read about it, wondering when it would get to us. And now it's at us. It's a tough question, because we do want records available to the public. I think that's important. I think the evidence, when it's brought forward, as Mr. Cora mentioned, typically will come forward in some kind of challenge to a permit or something. But that's useful evidence. It's important for us to be able to make decisions in those cases that someone's been able to look at this. But the problem I've got is there's nothing free. I mean, it actually takes real dollars to do this. And I've been pondering, well, what's the best way to pay for it? And I don't have a particularly good answer for it. A&I spent a bit of time thinking about it, and I think they've come up with a satisfactory approach for paying for it. I don't know. I'd be great if it was free, but it's not. It costs somebody something, and somehow we have to figure out a way to pay for it. A&I has spent time on this. I'm willing to go with what they've come up with, but certainly appreciate the comments that the folks have brought forward on this.
Tim?
Yeah, I agree with Dave. And I'd go one step further. It can't be free. There needs to be some sort of mutual deterrent. And if you need an example, just look at the federal government and the issues that we face every day with the BLM and the Forest Service and the Freedom of Information Act. I mean, our range con spends half his time giving documents to Western watersheds when he should be out taking care of the actual resource that he's supposed to be supervising. So if there's not some sort of cost for the people that are asking for this all the time, it can get completely out of hand. And that's just one of the bad things about it. Dave's mentioned, and some of the other people have as well, that, I think John mentioned that you find one little thing and off you go and throw the whole process off the rails. So I agree there should be access and people should have a right to get where they want, but they don't really have a right to be burdensome to the people that have other jobs to do and other responsibilities, and also have the right sometimes to make a mistake and not be completely crucified for it. So, I think this is a reasonable enough way to get at it. And I think that, if there's complaints about the cost, well, as far as I'm concerned, probably they're not high enough. So that's my take.
Steve?
Thank you, Madam Chair. I agree with the comments that have been made. I value the process that has taken place to come up with a fee structure. and I feel comfortable with what we've been presented.
Thank you. So, I have two sides to this issue. I understand the need for public access. I certainly enjoy being able to access documents online and not have to leave my house, which is also a long ways from everywhere. If email is a public document, is there a way of making them public? But how does that work with privacy concerns? I don't know. And then I do have issues with nonprofits asking for special dispensation. A lot of the operators that we work with are small operators who are kind of holding body and soul together and trying to produce a product for the state. And, you know, one time we made a public document, a FOIA request to the federal government. It cost us like $10,000. And I find it very frustrating to hear that the NPO that might be opposing us gets to do it for free. That's just my opinion. You know, they can gather money from other sources if that's their desire. You know, this is a tricky issue, and the email thing I think needs to be solved overall because it is. But on the other hand, they weren't recording phone calls, which is how things used to get done. I don't know. This is a hard one. Is there any other discussion by the council? No? Then we will vote. Steve?
Aye.
Tim? Tim?
Hang on a second, he cut himself off.
Oh, okay. Dave?
Aye.
John?
Aye.
Deb?
Aye.
And I will vote aye also. And we'll get Tim back on the line so he can vote.
Now the question is, how do I do it? I was on a conference call. One of them got lost. Anybody got a suggestion?
Can you get the conference again?
There is no conference.
Hit the down button.
Down, but
She knows how to use it.
this is the number. Better redial.
Try that, yeah.
We're sorry. Your call cannot be completed as dialed. Please check the number.
We haven't redacted anything.
We forgot the, there's a missing number. There's no.
You forgot to deny.
And it canceled, okay.
You can just.
Better this email.
So you get 145 emails.
Oh, is that
It's
what?
$180 at 2 minutes. That's the math I was trying to do.
All right, you're back. You're back.
I'm there. Can you hear me?
Tell them to vote before you hit any.
Steve, are you there?
I think we might have lost Steve.
Tell Tim to email his vote.
Madam Chair, I think if you could just get Tim to vote the next time Jim makes contact with him, we
Hi,
can
Steve.
close
Hang
this
on a
part of
sec.
the agenda.
Steve, Tim, you both there?
I'm here. Yeah.
Okay, Tim,
Yeah.
how do you vote?
Aye.
Okay, it's
I
been,
think, I don't know that I heard the motion. I'm assuming that's in favor.
yes, it is. So the motion passes. And we'll move on to our next item. Thank you guys very much. Thank you for coming. Yeah. Yes, why don't we take a 10-minute break so everybody can take care of personal business?
Excellent.
Take care of personal
idea.
business.
Thank you.
I just took a break. What were you guys doing?
Right on.
The release of private contact information of council members. And the current policy is, Jim asks us if our information has been requested and we say yes or no. Do we want to change that policy or do we want to continue on as is?
Well, Madam Chair, I think the policy as is fine. I mean, each council member can determine what information, when Jim asks, what information they feel comfortable releasing and go with that. I mean, I think there's definitely reasons to not have private contact information available, but a council member, if they have a contact, a sort of a public contact point, there's no reason to not share that, but it gets rooted through Jim, and I think that works.
Anybody else have an opinion?
Madam Chair, our current policy, just to briefly reiterate.
If I get a request, say, John, for your phone number, I'll call you and ask you whether or not I should release it or not. And I do it every time because each requester is a different person. You know, sometimes you may want that person to be able to get hold of you and somebody else not.
Sure. Okay.
Or an email at any kind of, you know.
Tim, do you have an opinion?
That policy works for me. I mean, especially for somebody like me who's not going to be there much longer. I just assumed it wasn't on something permanently and it's going to follow me around after I'm gone.
Although you can just look up your name on the internet and it comes right up.
Yeah, I mean, like I said before, if people want to get a hold of somebody, it's not difficult in this state. You can always find them. I mean, this isn't a hardship that we're placing on anybody.
Steve, do you have an opinion?
No, I like the policy that we have now.
That's my opinion also. I think just continue with the policy that we've got. Just run everything through Jim or whoever and make sure that, you know, because again, it could be different people and we might not want everybody. Plus, we don't want any appearance of conflict of interest. So, okay.
Madam Chair?
Yes.
If I could just say a few things on this, because
Sure.
I think I started this conversation.
It was a good conversation to have, though.
And this got started because I have I have all your phone numbers and I have all your emails.
Yeah.
All right. But I was in a location where I didn't have those accessible to me. I had asked my executive secretary to contact Jim and just get some numbers. This is during work group stuff. And there was a series of email correspondence that I think created some confusion as to, okay, well, what are you asking for the information for? It wasn't coming directly from me, so I can see where that confusion came. But I just want everybody to know I do have all your contact information, as you know, because I just recently sent you. So, anyway, so my apologies if we created some confusion or angst there.
No, I think it's a good discussion to have every once in a while and make sure we're all on the same page and everybody knows what policy is. Thank you very much. Okay. And discussion regarding number of votes needed for passage of a motion. And we need to have this discussion because the legislature is going to have this discussion and I need to know what to say at the Minerals Committee meeting. So I will start with Tim.
Well, I think everybody's already heard how I feel about this. I think it's just a Pandora's box. I think you end up opening just as many problems as you solve. And as far as I know, unless somebody can explain it to me differently, it only absolutely solves the problem when there are exactly 5 people. That doesn't seem to me enough of an incentive to waste the legislature's time with a new law. I mean, we've gotten by all these working around this thing and with really not so much hardly as a hiccup. And it just seems to me that when you start making laws for outliers, you create a lot of issues that are maybe unforeseen. And I really believe that's where this is going. There's a lot of room for some manipulation of council votes and appointments and different things going on. And I don't think that ever could have happened in the years that I served. I think everybody served with a lot of integrity, and I think the DEQ has acted the same. But when you look at the political environment going forward, I don't think you want to give them any help to do things that might be able to make the council manipulated by who's present and who isn't, and when you schedule a meeting and when you don't. I mean, if we're going so far as to say that we should have a law that the director can call a meeting because, as Dr. Bagley said, the chairman refuses to do it, now we're getting into petty politics. If we're worried about petty politics, what's to stop that same chairman from manipulating a more favorable 5-member council at a certain time when he's aware that somebody else can't be there, and getting the votes he needs to swing his agenda? So you can't say, well, that's not going to happen on one hand, and yet it is going to happen on the other. I mean, it either is, and it's a risk, or it's not. And those laws or those rules that we approve or don't approve should go hand in hand, as far as I'm concerned. If there's room for manipulation in one area, then there's room in another, and if there's not, there's not. So, I mean, I cannot stress strongly enough that I think this is a bad idea, and I've been there a long time, and I don't ever remember a position or a situation where this was needed. And I can tell you some of those rules and regulations that we passed at the last meeting don't do a whole lot of good to encourage people to step up and serve. And things you lay down there to frustrate volunteers like myself and the rest of you council members, the less likely you are to have a nice cohesive board of good professional people that can move this stuff along pretty fast. So I think you leave it alone. You encourage good people to serve. You encourage them to make the meetings and participate. And again, you guys have heard all this, but there's a reason there's 7 people, and there's a reason they come from the places that they come from. And anytime you just agree that we can do business without any number of those people on any given day, that's just a bad message that you're sending, not only to the council members, but also to the people we are supposed to serve. We're supposed to be working double hard to make sure everybody can be there. And those of us that serve are supposed to be working double hard to make sure that we can be there. And the more loopholes you have in there that say, oh, that's not so important, the less likely those people are to show up, and the less likely our citizenship is going to have that much confidence in it. So you all know what I think. So anyway, I will be quiet now. You guys can take it away.
Thanks. Steve?
Well, thank you, Tim. I always appreciate your comments. It's good as a new member to hear everyone weigh in, and each of us all have a different background, as you pointed out, and we come to this with our thoughts. And I've come to find in my short time on the council that as we listen to it, it's good that we have time to think about it, time to mull it over and really work through the ramifications of going one direction or the other. And as I sit here and review the memorandum that came from the AG's office, and that it surely clarifies that our decisions are difficult, and it does require all of us with our backgrounds to come together and to weigh in and to be present in these decisions that are quite often fairly momentous to either the state or the individual parties that chose to come before us. So I agree with what Tim was saying. I think that in this appointment we have a responsibility to have looked at ourselves and what our abilities are to participate as needed. And I think we should continue with the way the statute reads, with the majority vote of those on the council versus changing the majority to being who is actually attending a hearing or a meeting. So that's my thoughts on it. Thank you.
Deb?
I'm going to defer to John first and to Dr. Bagley. I'm really riding the fence on this one.
Okay.
And I would just like to hear the general discussion first before I weigh in.
John?
Madam Chair, first of all, we voted at the last meeting on the recommendation to go to the legislature, and my recollection is that we decided as a group to not recommend to the legislature a change to that language. So a lot of what's been said so far, I think is taken care of because the council did in fact weigh in and on a vote and say, okay, we as a council are not going to recommend a change to that particular part of the statute.
Until we had this meeting.
No, that report's gone on. It's been filed with the legislature, hasn't it?
But they're going to ask specifically, separately about this issue.
Well, Madam Chair, and if you're seeking our counsel to you on that, I guess I would like to come back to that. But I kind of thought, in fact, I didn't kind of think, I specifically thought that after our conversation last week or the other day when we had our last council meeting, going forward, and let me just back up one step. The issue, for me, the issue was more about the orders of the agency, okay? And that issue had to do with when the agency comes to us with an order, and this council is unable to make a decision on that order, the agency is left without any capability to follow up on that. And I thought that was serious enough that we should address. In the recommendation to the legislature, I think the language about orders coming before the council has also been stricken. Is that correct?
Mm-mm.
You didn't do that? I thought I read that.
Just one part, John.
Yeah, just the one part.
Yeah, because it was in conflict with another part of the law about orders, so we wanted to just have just one spot.
Yeah, and so my sense is the anxiety I had over the orders went away. And so for me, coming out of the last meeting, I thought that the issue was very narrow in my mind, and that is, what happens when the agency has a tie vote? Or excuse me, when the council has a tie vote? For me, that was the only thing. And we talked about the rules of parliamentary procedure, and Mr. Ruby brought up at that meeting, or one of those meetings, that, well, a tie vote means a no vote. And so the question came up for me around, well, if a tie vote is a no vote, is that something that we're willing to live with going forward? Tim says, well, it hasn't happened very often, so we probably ought not to worry about it. And I'm okay with that, but there are solutions that we can just by modifying our practices, you know, and we can do that at the beginning of any of these meetings if we are shorthanded. And we can do that, I believe, Madam Chair, by having the chair not vote, because the chair, under parliamentary procedure, the chair doesn't have to vote if you don't want to.
Always wondered about that.
Madam Chairman, I feel I'm not clear on this. I think John's tried to explain this to me a time or two, but in the eyes of the DEQ, what is the difference between a no vote and a vote where they don't get a yes vote? I mean, from their standpoint, don't they see it the same? I mean, if they lose on a 4-3 vote for an order, or they lose on a 3-3 vote, what is it the same way? I mean, it's not really a no call. They should. My understanding is they approach that scenario the same way. So to be clear, if the DEQ brings an NOV in order to the council, say they bring two the same day, and one fails by a 4-3 vote, and then we have a member recused from the next one, and it comes down to 3-3, so it fails. Why would the DEQ view those scenarios any differently? That's what has never been explained to me. If I understand John's argument, he's saying, well, one is a majority vote and the NOV in order failed, and the other one's a no call. And to me, it's not a no call. It failed just like the other one. So can somebody explain the difference to that?
I'm going to ask a couple people. First, I'm going to ask Director Parfit, and then I'm going to ask Jim a question, and then maybe this will clarify it.
All right. Thank you, Madam Chair. And Jim, you're right. That's really, I think, the crux of the issue. As I see this, it's less about whether or not it's 4 votes for a motion to pass or 3 votes for a motion to pass. And there is a distinction, Jim, in my mind, and that is you make a motion, and you can decide how to make that motion. And if that motion does not get 4 affirmative votes, then it fails.
Right.
The motion fails. The issue is not resolved because the motion, you need a motion that carries at least the mandatory 4 votes in order for that motion to carry. And so if you haven't made a motion, then this is our view. If you haven't made a motion that has the requisite 4 votes as the statute reads today, then you don't have an action by the council other than a failed motion. So you have to then rework the motion so that you can get the requisite number of votes to pass a motion and actually have an agency action. Otherwise, I would argue that you're already at what the Minerals Committee is asking for, is that 3 votes would pass. Because otherwise you have 3 votes for and 1 vote against, and the 1 vote against prevails. And that's why.
Oh, okay, I understand that, but if all we're going to do is change the majority of the vote of those present, that doesn't really solve our problem, does it? I mean, we can still run into this same thing on other numbers of council members present or not present. I mean, I think it's a good problem and we should look into solving it. But this thing, just by changing the majority to a 5-person council, doesn't fix this problem. It only fixes it when you have a 3-5 vote. That's the only scenario in which this law fixes our problem. It doesn't fix it at 3-3. So that's my issue with this changing the law. I agree we should probably try to work through this and figure out how we should address it. But there has to be a better way than this. Just looks like a checkers move to me. That's what I've said before. We need to be playing chess here. We can't go to the legislature and say, well, this fixes it 1 out of every 5 times it comes up. That's not where we want to be, is it?
Madam Chair, may I quickly address one point?
Let me say something first. And this is based on what Director Parfit said. I mean, the motion would be, do you grant the, say, NOV in order? And whether it fails, either way, it still failed, and the NOV doesn't fly, right?
I would disagree because the way the statute reads, the council has to have 4 affirmative votes, make either issue, deny, or modify an action by the agency. Without those 4 affirmative votes, there's no action by the council.
But then but if we haven't ratified the action of the agency, then the agency can't take that action, right?
I'm sure I would agree, but there's no action by the council. So we would have to come back until the council could actually have 4 affirmative votes one way or the other.
Yeah.
Okay.
You're just sitting in limbo, basically going,
yeah.
Okay, well, we can't do anything.
And okay. Madam Chair, Tim, it just a point. Let's talk about the example of 4 people being there, which then meets the threshold for a quorum. Robert's Rules of Order, also one of the basic tenets of Robert's Rules of Order, which none of us are experts at, but that one of the basic tenets of that whole procedure was to make sure that a minority could not control the decision of a majority. And your example was a perfect one that supports that issue. If it takes 4 to make an action, it's there, a single person can derail an act. It could be a minority, but it could be a minority opinion. That's what right? And he could derail the whole thing. And so it sort of de facto gives more power. The way we're currently set up, it does give more power to the minority, and that's not fair. And of course, I agree with the limbo part that was brought up a minute ago by others. And I think tie votes say no, and I kind of wonder if that's fair too, but it is a separate problem. But this other thing about leaving the agency up in the air, I don't think that. Well, my opinion is we need to try to fix that somehow.
Madam Chair?
Yes.
Whether the statute is clear or not, I think you can probably do it by policy, because there's always a chair at a meeting at which we have 4 members. And if your policy is to break a tie, which is possible in Robert's rules, then, but it does put an extra burden on the chair that I don't know that a chair wants to accept. But, there are other ways to get around this, I agree. But, so anyway, I'm done for the time being.
Go ahead.
Yeah, so, yeah, I've been thinking about this a lot since it came up. And it first came up when the legislature asked Megan at the committee at their meeting whether they were thinking about this, and you hadn't had a chance to talk to the council and said, sure, take a look at it. The council, our report that we just submitted was to address something completely different. This was a possible thing, and we decided, the council's not ready to make that recommendation yet. The legislature has asked us to do a report on one thing, then they ask us in a later meeting about something else, but we need more time to think about it. So I think we're in that. Let's think about it. What's the right thing to do, so that when the legislature asks you again, Megan, what to do, you're able to say, well, this is what the council feels. And as I thought about it, and in our meeting in September, we asked Ryan to prepare a brief for us to explain the law a little more clearly, and that was I found that very helpful. It explained, in particular, the case we just had where this came up, where we had, it was the good case where we had a 3-to-1 vote. And so you'd say, wait a minute, 3 people voted yes against 1. That seems like a majority. But the law says, no, it has to be 4, because I think we had 6 members of the council at that point. I think we still had a vacancy, but we still needed 4. And so it seemed funny, because we're just not used to that. It was like, wow, wait a minute, the majority didn't rule because of the law. And I know that it was really hard to write the council's order, because 3 members felt one way and only 1, but it was, in that case, it was, how do we write the order for it? And the DEQ didn't get the kind of feedback they needed to move forward. And I remember DEQ then saying, hey, you guys got to come back and deal with it. Well, actually, as I've thought about, and I've listened to Tim's thoughts on this and thought about it, I'm okay with that, and then with the information we got from Ryan and looked at, we as a council could have had motions in a different manner that would have let us address the issues, both the violation and the order, separately, which we didn't. We did it together, but we actually could have addressed them. In fact, maybe we should address them separately. And I think in that case, just remembering that particular case, because I think that's the one that sort of brought this up, we would have been able to handle one of them very clearly, and we could have sat down and looked at the order aspect of it separately as well, and at least dealt with one of them. But but we didn't, and having the DEQ then come back and say, hey guys, you got to do something. That's all right. By that point, maybe we step back. There have been more people on the council. We could have said, all right, we need more council members. Go read the transcripts, whatever else, and come to a solution so that we can get the law requiring 4 votes. So, it kind of caught me by surprise, as I'm so used to majority rules, right? 3-to-1, that should have been a majority. Turns out that isn't the case here, but as I've thought about it, And again, I just hate to say this, but I agree with Tim on this one. But we could just make it works. It may be a little inconvenient at times, and I could tell the DEQ, we weren't thrilled to not be able to give you an answer at that time either. This council likes to get its business done and move on. So, but in the end, we got to the right solution on that.
Well, so this is Tim again. I don't want to be grandstanding, but I think to simplify a really good point that Dr. Bagley makes, and I'll give you an example. We had a hearing years ago, and John, you'll remember this. It was the one up here in Grable, and Dennis Bull was the chairman, and he knew kind of where the votes were going in. So he kind of wrote, I can talk about this because I was recused, but he kind of put the proposal forward that he knew he could get enough votes to pass, and got it done, and we were able to move on. And I think that maybe we could put that in some sort of an understanding and give to the legislature that, hey, we're going to try to adopt a policy that we just are not comfortable walking away from the table without some sort of a decision, that we need to like Dr. Bagley said, work it amongst ourselves until we get a motion that we can all agree on, instead of just throwing up our hands. That was really the mistake we made, probably, is to just to leave it lay. We maybe should have thrown some motions around, because there's almost always a solution. And maybe our job is to do a little bit more work there in the room and try to find that, instead of just saying, well, that's the vote, that's the end of it. Maybe that's our part there, to have a new motion. Let's get something done, give some people some direction.
Madam Chair, there is room to do that in parliamentary procedure by motions to rescind or take, I'm getting the other word, but take back. So,
I would say that, yeah, I agree, Tim. It just caught us by surprise, right? And it was a telephone call. We had people calling in. I think Deb and I were the only ones actually in the room, and everybody else was on the phone. It just caught us by surprise. The good news was the DEQ said, hey, you guys aren't done, and told us to get back on it, as to point that out. So one thing I feel comfortable in is that if we, accidentally don't get something resolved for a reason or another, and there'll be reminders to help us.
Madam Chair?
Yeah.
I'm riding the fence on this, because in a lot of respects, I just think that we should make the legislature do it to us instead of the other way around. If they want to change it, let them do. They might anyway.
Right.
They could maybe care less as a group what we think. And in the meantime, just, keep it as it is and try to work it out. I agree with Tim and Dave, and that case took me completely off guard, and I handled it wrong. As I think about it, as I thought about it after we all hung up, I'm like, oh no, what did I just do here? Instead of doing exactly what we talked about, rework the thing so that there is a for vote on something instead of what happened. And I think it could have worked out. But
that's why I hate phone call.
Yeah.
I really hate phone calls for hearings.
Mm-hmm.
But I think the thing is, it could happen to any of us. These are complex cases, and in that case, the process ultimately worked, and it would have worked if we had come back together. We would have figured out a way to get the votes we needed. It can happen.
Yeah.
And as it turns out, they came up with the solution. There was a settlement, which is our ideal solution anyway.
That was our plan all along. Now we'll share that. That was our strategy.
So,
okay.
I'm off the fence, and I just kind of agree. I'm going to agree with Tim on this as well, that I don't think we should do anything. I think we should leave it alone.
I think we're setting a new world record today.
Everybody agrees with Tim.
Yeah, don't get used to it, Tim.
Yeah.
I'm going to resign tomorrow on a good note.
So I said I had a couple questions for Jim. One is, we don't follow Robert's rules. We certainly really don't. I mean, we do our best, but it's not part of our mandate, is it?
The rules of practice and procedure, right up until
I'd have to go back and look, but at the time that was happening, did say that we would follow Robert's Rules of Practice and Procedure on any procedural rules that weren't covered by statute or by rule.
Okay, and this is statute, so, under Robert's rules, because I was in high school last time I really read through Robert's rules. Does the chair vote or not, or is it up to the chair? Does anybody remember?
What's that?
It's all dependent upon the rules that may be or may not be adopted by the entity. So like in many senates, the president of the Senate doesn't vote except to break ties.
Right.
But that's set out within their procedural rules.
So that's a procedural rule. It's not in
Robert's Rules and Orders provides for it in certain circumstances, but it can be overridden by whatever the entity is by their own rules. This one is a statutory provision that requires all orders of the department to be approved by a majority of the council. So you're a member of the council. You can certainly abstain, but because you are a member of the council, your vote counts one way or another.
Okay.
It's either an abstention, which in many ways but doesn't register that way, or you can vote whatever your sense is. And certainly you can make a decision in your own mind. I'm going to abstain from anything unless there's a tie.
Right.
You can certainly do that. The chair, there's no reason that requires you to vote.
Okay, and then also, I asked him this because he's the longest serving member of the council, but you've been here. Has anything like this ever happened before?
No.
Okay.
But let me tell you, it came close. I mean, we've had close calls, but this case was really unique.
Because there was nobody, there was only 5 of us.
You had a council member who misbehaved.
Yeah, there were only 4. Right.
You had a council member who was on this council and misbehaved.
And got recused. Right. Which led to a very small number of us being able to make a decision. Right. And we were short somebody, and somebody was recused anyway. Yeah. We ended up with 4 people. It happens again.
Well, I tend to agree, and I think if we make a conscious effort at the beginning of these hearings to recognize what we have in the way of membership at the meeting, and look at the situation and review all of our possibilities for handling unintended consequences, and then follow those, I think we can resolve. It resolves my concern about ties, and I think we can do that without writing a bunch of rules or modifying the rules of practice and procedure to do it.
Okay, so would everybody's recommendation, and I'll say this to make Tim feel better, I happen to agree with Tim also, but I will do whatever the majority of the council wants to do. So is the recommendation, if the legislature asks me what to do, say, we're happy with where we're at right now when we feel like we can work within those rules?
Madam Chair, I think you might even go on to say that we had a robust discussion about it, and we reminded ourselves we do have other ways in which to make sure at the outset when we have these small, we have situations where there's only 4 people in attendance, then we've got other ways to resolve that, and we'd like a chance to execute that if the problem comes up again.
Okay, thank you guys. I appreciate it. Is there any other business? Seeing none, could I get a motion to adjourn?
Move to adjourn.
Second.
Moved and seconded. All those in favor?
Aye.
Aye. Thank you guys for calling in.
Aye.
Sorry about all the problems with the phones.